And before we start, I'd like to introduce the colleagues who are helping me today to facilitate this meeting. Ann Birch is the one starting and stopping recordings, and David Berger will be taking minutes for me today throughout the meeting. Kyle Rose will need to be the one to monitor conversations. So if you're giving a comment verbally and you reach the 2.5 minute mark, Kyle will be the one to say 30 seconds left, so that gives you an update and you'll know that your time is running out for that comment. Eleni Yelorikis will be monitoring the chat for us today. And Lynette Caldwell will be keeping people on mute to try to help decrease, hopefully, our background noise. And then we also have helping us out today, Deb McCune and Naomi Sachs, who spoke at both of our first two racks on the topic, and they are here today too, and I invite them to speak up as needed whenever there's a comment that needs to be made. What we did on October 4th, we presented background information on the purpose of this rulemaking exercise, and we gave it to members and advocates for nursing facilities and community-based care facilities. On October 26th, we gave the same identical program to the adult foster home providers and advocates. And the reason we split them was because we know there are so many adult foster home providers who signed up to be on racks and get notification that I was afraid it could crash our system if we included everyone in that first initial meeting at the same time. So instead, what we did was to have the group select, and people, we had, I think, 8 participants who said they would like to be on the rack, the formal rack going forward, as representatives of adult foster homes. And so those 8 have joined as the official members who will be on the rack. And before we get started, I'd like to just share that list. I was going to send out an email, and frankly, I was afraid 4 attachments is generally already one more than I like to send to accompany a rack update, just because it can be overwhelming to read, and it's also overwhelming on your screen. But what would I do, Lynette, if I want to share this? Although I've attended a number of Zoom meetings, I've never facilitated in one, so this will be an experience for me.
Okay, so I've made you a co-host, and you should have a share screen button in the bottom center.
All right, did that work?
Not yet.
Okay, because it says screen 1, screen 2, and I double clicked it.
It's starting to share. Okay, now we can see the ground rules sheet. Is
Perfect.
That what you're going for?
Thank you. That's exactly what I was going for. I appreciate that. So this list, these are the official members of this rack. And you'll see we've got folks representing all sorts of external groups who advocate for facility types or for residents. And we also have some consultants. And then we have folks who were on the coalition that drafted the bill and got it through session, who are joining us. We then have adult foster home providers and representatives. And finally, at the bottom, we have the official agency members of the RAC. All right. It doesn't mean that others cannot offer comment, but I would ask that you either do that in the chat, or hopefully you can wait and hold verbal comments until we get to the public comments section, which we will have later in the meeting. All right. But I just wanted everyone to know these are the names of folks who are the official RAC members who I will invite to speak at any time during the meeting. You can do that either by putting comments into the chat or by just raising your hand, and then you'll be called on and you can speak. In addition, this list here also includes all agency staff, I'm just realizing I might have had 2 more people to add to this list who joined last night. So sorry, but most of the folks who are joining and listening in as agency people are listed here. And I like having a lot of agency people because we're all going to be the ones implementing the rule once it's finalized. And so having as many of us listening to the conversation and to your comments in particular as possible only helps us make the rule better. So that's why we've got a lot of agency folks on. Then we again have the ground rules. These are the same ground rules that we introduced at both of the first separate RAC meetings. Again, now this will be our first combined RAC meeting, but these rules will be the same. So it's the same, be respectful, keep yourself muted if you're not speaking, and keep chat professional, and just being aware that at least at this RAC, we won't be reaching final decisions during discussion, but we still want all of your feedback because that will help us going forward. Also, here's what was called the 3x3 rule, which means if you do make a verbal comment, which I certainly hope people do, please keep your comments to 3 minutes or less, and then wait until 3 or 2 more people have spoken or 3 minutes have gone by before you go ahead and speak again. Again, if you get to 2.5 minutes in one comment period, Kyle Rose will speak up and say 30 seconds remaining, just so you know your time will run out. And again, the very last section of our ground rules document are the glossary of terms that we here were just thinking you might need to refer to. We're going to try hard not to use acronyms today, other than probably RAC, but it's sometimes it's difficult for us to, in the agencies, to not do that and to remember. So if we use a term that you aren't familiar with, try checking here to see if this answers your question. With that, I think I will turn the screen over. So I just hit, I'll bet you stop share. Yeah.
Lynn,
Yes.
this is Eleni. There is a question in the chat, and it's
Okay.
asking if there will be an official, if you'll send out the official RAC members list to the group.
Sure. Yes, we will. Good suggestion. And we'll be writing that down right now. So thank you. All right. With that said, I want to turn back to the agenda. And again, to let you know that we know this timeline is compressed. However, I was guessing up front when I first learned that SOQ needed to do this rule and that I would be facilitating, I thought, all right, we could need up to 5 individual meetings, I'm guessing. So this is only meeting number 2. Let's see, or would it be 4? Yeah, I guess we did 5, but only 4 meetings that are for each group. So this is meeting number 2. We will also have a RAC that will come out, or that will be posted, for both the first week of December, the second week of January. So we missed the first, we missed that week, and then the first week of February. So I am anticipating that we will have this RAC in addition to 3 additional RACs to finalize the permanent rule. However, again, and I know this gets confusing, we're required to do this in 2 stages. The first stage is to implement a temporary rule that has to be in place by January 1st. And because it takes us quite a while due to all of the requirements that we have for posting and notifications, that can actually be a 4-month process on its own. For that reason, the only option we had to get a rule in place was to use a temporary rule. This will be the last RAC before the department needs to file that temporary rule. And what we're going to do is we're going to have you give comments today to us verbally, and then you will have 1 week to provide additional comments in writing to make it into the temporary rule. The department will then be reviewing that language, and on December 1st, we have to file for the temporary rule to ensure that it's in place by January 1st. We will, on December 1st, when we file, we will also send to all of you that version of the temporary rule that was filed. Again, however, this is just the beginning, because we will then have 3 additional racks to play or to edit that temporary rule before it becomes a permanent rule. And I want to stop for a minute and ask if anybody has questions about all that, because I know it's confusing. Okay, seeing nothing at the moment, we're going to just jump in. What I would ask now is that David, go ahead. I think we've talked about everything we've got. Actually, could you scroll down for just a minute, David, on the agenda, please? Keep scrolling down to the next page, and stop. Perfect. All right, you will see there that we have listed both the deadline for any comments that should come into me following this rack. Please get me any written comments you might have by close of business next Tuesday, November 14th, to be included in the temporary rule. Again, it will be up to the department to decide what we use, what we don't, but I always respond and let people know if we don't end up taking your comments, there will be a reason. And I will tell you what that reason is. So I will do it either as a single block response and just not give names of people who commented, but let you know what the comments were, and then explain what we took and what we didn't. So that, just letting you know, your comments will all be read and you will find out what we do with your response. The second thing to again point out is what I was just talking about, which will be the dates for the 3 additional racks. And thank you, David, for highlighting those. So they will be Wednesday, December 6th, Tuesday, January 9th, and Tuesday, February 6th. Those will be the final 3 racks, because I think we'll probably need all that time to really make sure that this is very clean language and that it meets the needs to implement the bill. What we're also going to do today when we're off this call, if it turns out that Zoom seems to be working better for folks than Teams did, and one of the reasons we switched to Zoom, oh cat, I have a cat pulling on the camera, let's not do that. One of the reasons we switched to Zoom was to accommodate adult foster home providers, because I know a lot of those folks work in Zoom frequently on meetings. They're not as used to Teams, and that was the reason we switched over. We're frankly also hoping my audio lasts this meeting. I continue to have issues. I've had people in trying to help me fix this. It is one of life's little odd mysteries, but if my sound goes out, with any luck, actually it won't, knock on wood, but if it does, I will come back pretty quickly, but it does seem to be happening fairly consistently. So I'm just letting you all know that. Okay, any questions at this point? Liz James, okay, will the additional, oh, good question. Yes, they will. All RAC meetings will run from 9 a.m. to noon. Thank you. And appreciate that, and thank you. So when we send out the Zoom notifications for each of those meetings at the end of today, is my hope, you will then see that's 9 to noon, but thank you for the question. Any other questions? I also want to say, we did this on purpose, but I don't know if this was a mistake or not. In our last rack with adult foster homes, because I knew I'd have so many of them, and thank you, Eleni. And so we did not include everyone who'd been in the first rack. The people who are invited to the second rack are people who have signed up to get adult foster home notifications. And knowing how many they are, there's almost 500 of those folks. And knowing that occasionally it feels like we have all 500 to come to racks, I really wanted to make sure we could accommodate that audience. So we did not include the audience from the first rack. So that's why some folks have wondered, wait a minute, I was in one, but not the other. That's why we were going through the same language with them. We presented the same background presentation. Deb gave a great background for that. And then we also walked through the language of the bill the same way we did last time. and letting you know, are there any questions? Thought I heard something. Okay. Letting you know that all comments that were provided during the first rack, we have attempted to incorporate into the draft bill. We know there's still work to be done, and I'll explain that as we start through, but I think we've got a good start on getting rule language drafted the way that makes sense. And what I would recommend today, as I'm now going to ask David now to please switch over to the rule language, what I'm going to be doing, so that you all know, is I'm going to keep the bill up on one of my, I work with two computers, two screens, keep the bill up on one as we go through this. So if you have questions about how the language that we've presented and provided, how it comes up, then we're going to walk through this part of the bill, and I'll show you that. The other question, or the other piece though, David, sorry about that, that I'd like you to provide first is the crosswalk, so we can explain to the group how that works too. Sorry, I knew this would, I didn't mean to give you a bit of a workout today and following along, but I appreciate that.
One second on that crosswalk.
You what? The crosswalk was also sent to all of you as part of the materials. And what it here, yeah, there we go. Awesome. Thanks, David. What that crosswalk does is we put every section of the bill with kind of a little header on it, the way that we can remember what they're talking about, down the left column in chronological order, just like you're walking through the bill. And then as each of our three teams programs were working on writing our respective rules, you can then follow along on that line. So you can see, like number 2, definitions, you follow over, you see community-based care. It's that rule is 0540005, and it shows you the page 8 that the language that's being edited starts on. So that will hopefully allow everyone working off of their own documents to find the language quickly. Adult foster homes definitions, it gives you is division 049, rule 0102, page 1. So that's where you would go to start walking through each rule for your respective program. I'm going to be working today off of the community-based care rule because I'm guessing that's the document that most of you will be familiar with. But if not, we can switch next time and try a different rule. The only thing here that is not identical among the 3 programs is, and we're going to want to talk about this at some point, but probably not today. I doubt we'll get to it. But if you scroll down a little bit more, David, to the bottom of that page and stop, the reason, come up just a little bit. There you go. Perfect. The grade sections are sections that we have not yet written and therefore are not yet in this rule. Okay. And the main one will be the contractors training. We just haven't drafted that yet. We don't know where to put it in each rule. We're still discussing that internally. But that will be another piece that needs to be written. But to say on like rule number or section 6, paragraph 4 in the bill, which is the designate training leads. As you'll remember, I'm guessing there are expected to be 2 training leads designated. Well, in adult foster home world, that might be 1 too many. You might not have 2 staff on all the time who can do that. So we are proposing to make that only be 1 designated person in adult foster homes. So just letting you know, that is the only thing where the only part of the bill where we have slightly different wording among the 3 programs. Other than that, it's identical. Just wanted people to be comfortable about that. All right, David, with that, as you go back to the other document, I'm going to ask if there are any questions again. Anything from colleagues that I've forgotten to mention or that we need to bring up right now? I try to always give people a chance to correct me in case I made a mistake. It happens. All right.
Lynn,
Yes.
this is Anne. Good morning. I don't know if you mentioned this. I apologize. We are recording today. And
Yes,
yeah, okay, thank you.
that's okay. And you are the one running that. So thank you so much for doing that. All right, let us start into the language. And again, if you keep your crosswalk up, you'll be able to, and if you're in an adult foster home or you want to see how that rule looks, or you want to see how the nursing facility rule looks, you'll go to the page numbers that are in your own part of the language. Otherwise, again, just keep in mind, if you want to just follow along on the screen, you're going to be looking at the community-based care rule, but it will be identical language to the language in all three rules. With that, please go ahead, David, and scroll down to page 8. And this, somewhere on page 8, there we go. What we have done is we are including the language from the bill verbatim. So each section is in here exactly as drafted in the statute. We know that some people have suggested some additional drafting changes, but at least for this initial temp rule, we were trying to do exactly what we thought the bill was asking for, no more, no less. All right, so we're really trying to capture that language. So with that said, is there anyone who would like to make a comment on any of the definitions that we've added? Obviously, the new definitions are the ones here in green. Or do you want to make additional comments for other edits that you might think need to be made? Any comments on that or thoughts before we get started? Okay, well, hearing nothing, then let us continue going through, please, David. And let's just, and there's harass. Okay, stop please on harass. This one has me a little bit concerned, and I'll tell you why. Our adult protective services program, that APS, and particularly they're going out for adult foster homes and for community-based care facilities. So they're looking into they're investigating allegations of abuse, right? With harassment being one. Although harass and harassment are not specifically defined in their rule, at least I couldn't find them if they're in Division 20, I'm concerned about maybe having a different definition being used across our platforms. And so I'd like to know if there are any comments. I do see Eugenia has raised her hand. Eugenia, what is your comment?
Good morning, Lynn. I think I agree with you. I think the term harass and harassment has kind of a legal definition, and I think it's important to tie that back to a protected class, because I think if the harassment isn't tied back to a protected class, there may be some unintended consequences, given the fact that some of the language talks about offending a resident and creating what the resident's going to be deemed to be a harassing environment. But I do think it's really important to provide examples of what harassment can be under this bill. And I am wondering if it makes sense further down in the rules we talk about, for instance, not asking a resident for identification, right? If they're going into a bathroom. I think it's important to say somewhere in those, maybe we tuck it into the Bill of Rights, harass or harassment includes asking a resident for any type of identification related to their identity, etc. Because I just worry that if we don't tie it back to a protected class, that kind of creates some confusion there.
Interesting. Do we have anyone on the call from APS, from that program, Adult Protective Services? Sorry, I just used an acronym.
Lynn.
And if so, could you go ahead and comment?
Lynn, this is Eleni. I just want to take you to the chat. Liz James states that this absolutely needs to be in this. And then Valerie said, I will take harass back to APS policy. So it looks like there is somebody from APS. And then Liz is raising her hand.
Okay, thank you for all that, Eleni. Liz, yes.
Yes, good morning, and I am delighted to be here and am incredibly grateful for all the work that you and your team have put in to get us where we are with this tight timeline. So thank you so much for that. As somebody who identifies as an LGBTQ person and as an older person and supports and has supported older LGBTQ adults, you know, from my perspective, as definitive as we can be about these specific issues, this is why we have this bill. I get a little emotional about this. I hope you guys don't mind, but what we're trying to do is ensure that a group of folks and many older LGBTQ adults, I think I don't need to go through a lot of the things that happen, but we have got to protect them, and they feel vulnerable. And obviously, if you're in this setting, you can even feel that much more vulnerable. I know I'm not being very eloquent about this, but I wanted to be crystal clear. And I understand that we've got some legalese around how we define these things. But if somebody's got to go somewhere else in a document to find out what this specifically means, I think that's a problem from my perspective. You know, part of it is we are creating rules and they've got to be understood and they've got to be taken in. So you know, as much as we can keep these things intact. You know, I was involved in the negotiations on the bill, and these were some really key things that we wanted to make sure we had in terms of protection. So I'll stop. I think you've got my message.
Yeah.
And I'm hoping I'm not the only one on this call that has some thoughts along those lines as well.
Well, and I will tell you, listening to that and knowing this, would obviously be an important issue. What I would like to do, and we just didn't have time because it's ridiculous how long it does take to write something like this, even though the bill's not really complicated. It was long. And so making sure things are in every part of the rule where it needs to be took us a lot of time. And we just didn't have time yet to reach out to Adult Protective Services. But what I would like to do is to work with that team in the next week and see if they might be comfortable putting this definition into their rule, and then we would reference it here. So if they are comfortable, then we can put that into all of the abuse definition language and include it. And then here it would say harass or harassments are defined as defined in, and we just give the rule site. And whether or not we're able to say means for this audience, I hear what you're saying. And it's also, I think, what I'm hearing from Eugenia, that would need to be tied to a protective class. And I understand that and agree with that. So we'll just have to work on that. Eugenia, go ahead.
Oh, sorry, I'm in my car, so I might have accidentally raised my hand. But yeah, I agree. And I think if the definition needs to be in that general definition, I think we just put some more explanation that this means, you know, harass or harass means blah, 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 based on a protected class, and give examples. I think it is important to share examples of exactly what we mean by harass and harassment, because to Liz's point, it's serving a very important purpose.
Yeah. Yeah. Thank you for all those comments. Anybody else want to comment on that particular issue? Okay, Rebecca Miller, I agree with your comments. Liz and Eugenia, it is important to clearly identify this form of harassment. And if there was more to that comment, I'm only seeing the top part and then it disappears on me. So I will count on Eleni to fill me in if anything else was said. And David, thank you so much for taking notes. He's obviously capturing that. We also have folks behind the scene taking notes, just so you know, because we want to make sure we get all these comments. I also wanted to say I've had many people reach out and tell me, either because they wanted to listen to the recording again or because they weren't able to be at one of the racks, that they would like please to have recordings posted. We are working on that, and Ann Birch in particular on our team has been working with folks downtown who handle both our press and also handle our web design. And so we're trying to find a way to get that posted. Used to be possible, and then with changes, now it's not possible at the moment, but I'm really hoping we'll get that posted and be able to then share that link with all of you so that you would be able to get in and listen to one of the presentations or the racks again if you need to do that. I just wanted to put in that pitch and say, we heard you, we're working on it, but it takes more than one would hope or think it would to get that to happen, but we'll see what we can do. All right, any other comments on harassing or harass? Then let us move on, please, David, to the next definition that we've edited here. There we go. And it is the big one. Here we go. LGBTQIA 2S plus means, now that top definition is straight out of the statute. But because folks were asking us at our first rack and asking, can you please define each of the terms individually? We are working to do that. Now, transgender was already in the bill in a different place. So we've moved it here because it is one of the terms. And just late yesterday, finally, Deb McCune was able to get a list of what the current definitions used by our department for the other terms. We just didn't have time to put them in yet. So we're going to be sending that out in the next version of the rule. And so you'll all be able to see those definitions that we're hoping to use. And again, they are definitions that have been approved by the department for each of these other terms. And I'm just sorry we didn't have them for today. We tried and just couldn't get it in time, but it will be there the next time you see a draft. Are there any questions about any of the specific sub definitions of this LGBTQIA2S+? Liz, yes, go ahead.
Yes, thank you. I just wanted to note, as you define these things, there is a bit of, there are other terms, and I'm not suggesting we go and figure out every single term that exists, but here's an example. Same gender loving is another term that's often used in the Black African American community. So I'd like to see at least some sentence that that demonstrates there can be additional language and terminology, and that over time that's also subject to change. So I think it's important that we don't, that there isn't a menu that's going to be a fixed menu for folks. So I don't think it takes a lot to, beyond a sentence of clarity to show that.
We hear you and agree with that. And the terms that Deb received yesterday include a number of terms in addition to these. So that's one thing our internal coordinating committee is working on later today, is going through the list and determining in the plus, should we add any others right now to that plus category? And the one you've listed may well be one of the ones we should add. So, and again, if folks have specific sub definitions they do want added, then please do go ahead and send those in to me as an email or put them into a chat right now, and we will be sure to review them and determine if we've got an agency definition for that particular term that could be included. Any other questions? Deb, yes.
Hi, good morning, everybody. Deb McEwen here. There's been a little bit in chat, but to go back to Liz's point, there is language around plus and what the plus means. And I think we can probably get to a point, I hope so, where that plus expresses what you were talking about, Liz, that there are other terms and other letters, if you will. I don't mean that in any demeaning way. It's just there are lots of letters in this acronym. So I think we might be able to get there with the definition of plus.
Thank you. Yeah, thanks, Deb. Any other questions on this definition before we move on?
Lynn?
Yes,
I
Elaine.
was just going to note in the chat that there was a suggestion that perhaps this could be labeled as a partial list.
Okay. Thank you. Yeah, actually looking at the rule, I've got a way I could probably pull that off, but but thank you again. Comment is taken and we've got that recorded, and we will, it's not a bad definition. We'll try to find a way to do that. Good idea. And since I really can't see the chat, I really do appreciate Elaine, because I can either see people or I can see, yeah. So thank you for letting me know what people are saying. I appreciate. And I know I don't want to make David move if he's still typing notes, but as soon as David, as you're ready to go, let's keep on scrolling down to a few more definitions. And there we go. Sexual orientation, the definition has been put in here. Again, we just have to renumber everything. We put everything in alphabetically. That's probably obvious to everyone, but just to say that. And so that's why definitions for the topic aren't grouped together. They have to go in where they would go alphabetically in our definitional list. And I think that that might be it, but please check. Please, David, keep scrolling unless people have questions about that definition. Sorry, I should have asked. Any questions, comments? Okay, thank you. And people might notice that we've had to amend the language that was in the statute just a little bit. Okay, thank you. Go please, David, to page 31. But in the definitions, the way that, oops, well, no, 31. Yeah, you're right. I'm sorry. I'll be quiet and let you go. We'll just wait till we get there, because this is the next section. Okay, I was going to say we did have to amend the statutory language a little bit, because in our rules, the way that we're required to do it is the term means, and then we put in a definition, and not all of the language in the bill was presented that way. So we did have to, we didn't tweak hopefully the content in any way, but we had to reorganize some things just a little bit so that they would meet our rule parameters. Just letting you know why it is not identical to what you see in the statute. All right, we are now in the section. Actually, David, I'm sorry, can you go up to the top of this section a bit, just so I can explain where we are? And I apologize, didn't mean to make you go up and down. Stop. This is the section on resident rights and protections. It's labeled a little differently in the nursing facility program and an adult foster home, the title of the sections, but we each have an identical section. And so to make sure that everything is in here, we went sure and we said, fine, we're going to use our existing essentially Bill of Rights as general rights. So we put that edit in. And we've got a comment from Deb on potential plus. And okay, thank you. I'm going to let that go unless there's a need for us to talk about that one verbally. I'll let that stay in chat. Let me know if you want me to talk. But what we're doing here is we're we're presenting the Bill of Rights in 3 sections. The first section is the general rights, and we did add in letter C is what it shows up as here in community-based care, that says to be given informed consent before any non-therapeutic examination, observation, or treatment is provided. That language is straight out of the bill, but this seemed to be the right place to put that. So that line went into our general rights. And now please scroll down, David. And stop. And then what we said was, fine, we are going to put the LGBTQ plus rights into the rule exactly as you had them in the bill. So that's what we did. We made a standalone section that states the protections. You're going to see exactly what you had in the statutory language, and keep on scrolling down, David, a little bit. Hello? David, can you scroll down a little bit? Is that possible? Maybe not. I'm sure he'll scroll when he can. So let us ask you then the question. It looks like he's having issues with that. Are you able, or does anyone have comments, questions, concerns, potential edits to your statutory language? Because now would be the time. Of course, we would have to be consistent with what's in statute, what's in Senate Bill 99, because that is the law. But it is always possible that we could put a little more in here if needed to really implement the intent of the bill. So language isn't always completely identical, but we do have to capture what was in the bill. Okay, David, if you're able to scroll down a little bit, that would be great.
Lynn,
Keep going. And then if there are comments, I see that things are popping.
Lynn.
Yes, Eleni.
hi. So Liz suggested that she would like to potentially include subject to change or evolve in the potential for the plus for the definition.
Oh, okay. So she has a specific term she would like added to the plus part of our definitional section of the LGBTQ. Is that right?
That's correct.
Perfect. Okay, thank you. Excellent. All right. Does anyone have edits or comments about the LGBTQ IA2S plus rights as presented here? Again, this is verbatim to what was in the bill. Our intent was just to make it very clear that these rights apply. Keep on scrolling down then. Okay, we have Rebecca Miller has a raised hand. Rebecca.
Hi, I'm sorry, my voice is a little scratchy this morning. My question is about the protection from other residents. How is or isn't that able to be documented here in terms of a facility's responsibility? And I know that becomes a challenge in so many ways, but to protect from another resident who may be engaging in harassing or discriminatory behavior. Is that addressed in this section? I don't have it pulled up.
Oh, fair enough. Yes, it's on our screen right now. It's actually section D. So I was thinking, well done. You're getting us right to where we need to be, where section D does indeed, and this came straight from statutory language, does indeed say D, prohibit a resident from using or harass a resident who seeks to use or does use a restroom that is available to other individuals of the same gender identity as the resident, regardless of whether the resident is making a gender transition, has taken or is taking hormones, has undergone gender affirmation surgery, or presents as gender non-conforming. Now, we know that's just one item because that's just using the restroom. But I know that there are other prohibitions here in this rule, but if we need to say something in addition, I would be interested to know what that language would be and what you would like to see. Eugenia, yes.
So I think that language ties back to what a care facility and their staff cannot do. I don't think in the bill that there was any language around resident to resident issues. That's not to say that facilities don't have mechanisms to address resident conflicts and work through the issues to minimize conflict and to resolve them. But I think this bill, if you go back to the top, I think that section D relates back to a facility and their care staff cannot prohibit a resident from using or harassing a resident who seeks to use or does use the restroom that is available.
Good point.
I think.
Yeah,
I don't see all the language.
Yeah, I don't either. I get good point though. David, can you scroll back up to the top of the LGBTQ stop? There we go. Good job. Okay, care facility and staff may not take any of the following actions. You're right. It is specifically to facility and staff, but part of their job is to keep other residents from harassing. Residents aren't allowed to do things to other residents. That's in other parts of our rule. Is that something that needs to be addressed here specifically? And I'm trying to think of exactly how we might go about doing that. And if people have suggestions of where that would go, or if it could go here, I'd be interested to hear that. But it's an interesting comment. It's a very good comment. And in truth, we've also had our own staff is aware of incidents where residents have harassed staff who are LGBTQ, IA2S plus. And so we know that happens as well. And we weren't quite sure how to deal with that either. So what I can say right now is we've heard the comment. It's a really good one. And I can see at least part of Liz's comment. Eleni or Liz, could you read it to me, please?
Lynn, yes, I was trying to get to you. So Patty had a comment. How does E take into account dementia features? And then Liz's comment was, if there's latitude to add, I would like to see it included. This type of harassment is indeed happening. And then Brandy notes, are there any implications to include residents to this list?
Well, the only legal implication is this: we can't take action against a resident, right? We are only allowed to enforce on the facilities themselves or their staff. So really, that's why D is written the way that it is, because we would have to take action against the facility for not prohibiting the resident to resident action. Eugenia, go ahead.
Yeah, and I think we want to give this a little bit of thought because even with the facility, ultimately they can try to manage the two residents, but at some point, if it gets to the point of where it's severe and pervasive type of harassment, it's literally boils down to an eviction. And I know that's really, really challenging under the rules. So I just want to, folks to kind of keep that in mind that there's kind of limits to the license setting around what you can do with another resident. And truly the ultimate end game would be evicting another resident. And that's going to get challenging, which goes back to why I think harassment needs to be tied back to a protected class so that the other resident doesn't inadvertently try to say, well, now I'm being harassed and I'm being asked to leave.
Very good points. Yes. Yep. Right now, we're just going to tell you, we hear you and really good comments. We're going to have to talk about this because legally that's not something we can do. And Eugenie is right. We'd like to avoid either what's called transfers in the NIF world and I think also in adult foster home world, or move outs, which is the language in community-based care. We'd like to avoid those if possible. That's something that the department doesn't like encouraging, of course, but we'd have to think about how to capture that type of harassment and how to make sure that we're prohibiting that resident to resident. Any other questions or comments on this section? And Brandy, you have your hand up. Go ahead, please. Brandy? If at any
It looks
point
like she's lowered her hand, Lynn.
Oh, okay.
Oh,
Brandy, if you
sorry,
have-
it's me. I just needed to unmute. I was just talking to myself. Thank
do it
you.
all the time.
I
Yeah.
know. Thank you for that clarification around the department not being able to, necessarily hold individual residents accountable. And then, of course, the eviction process. It's a whole nother thing that we're not addressing. But I agree with what Liz is saying, because what we're finding is there's a lot of the issues are coming resident to resident. So I think it's very important to have an acknowledgement of that in this statement, in this definition, and understanding that facilities do harbor some type of responsibility to ensure that residents, of course, are safe, but that they also have access to training and information
Yes.
to help remedy these types of situations. So I think it's, if it's where it goes, if it's, facility staff, contractors, and residents, or however it wants to be added in, I think we need to at least make an attempt to recognize that there is some responsibility by facilities to ensure safety.
And just letting you know, we can't require trainings of residents. We do provide, or facilities provide them with information. Either when a legislation goes through, they'll hand out new pieces of information to all the residents, updating them on the new law. Or it will be included, in this case, it definitely will be included in initial packets at move-in, and there will be posters around facilities. But that's the extent that we're allowed to require. We can't require residents to be trained, unfortunately. Anyway, just letting you know legally what our boundaries are as an agency. Are there any other questions at this point? Good comments, and we'll see what we can do. Always up for a challenge. All right, then with that done, David, can you please go to scroll up to page 22? Yeah, what I'm doing is going chronologically by the bill, which for the most part follows through our language, but doesn't always. So I'm taking you through the order of the bill instead of the order that it's in any of our rules. All right. The next requirement in the legislation in section 3, paragraph 2, is that the poster or the posted statements be up in the facility and that they be handed to residents when they move in. This is a section, if you scroll up a little bit, David, sorry, I apologize. I know we keep needing to go to the top and then come back down. This section lines, keep going, stop, there we go. This describes how the facility what they have to do to operate the facility. And so literally it walks through what their responsibilities are. Go ahead and now scroll down. And background checks are required, everything else, the employment application, and says they're okay, thank you. These documents all need to be posted. So that's why we've got the current staffing plan has to be available. And most recent relicensure survey has to be posted, the ombudsman notification posted. We're also now saying that they've got to draft rights and protections as described in the bill. So in that one, we made the decision to send folks back to the statute. So they realize this is serious and it lays everything out and it includes everything. But then in G, we also said, you've also got to post the information. And then we inserted that information into a different section. But again, what we're trying to do is go through all of our rules and say, where would this language be most appropriate, and making sure it's in each of those locations. So that's why here you've got to have the rights and protections. Every facility will need to draft one to draft that document, and you will need to be able to post the information that was described and provided in the statute. Are there any questions on that? Please scroll down then, David, a little bit. And the next one we're going to is 28. Okay, stop for just a minute. Might as well hit there, deal with these while we're here. Again, this is where protocols are specifically listed. We've again said you're going to have to do everything. What the OL, these are Oregon laws, and people who aren't lawyers will go, good grief, why invent something so crazy? But what happens is you start with a bill, in this case, Senate Bill 99, being passed by the legislature. And then it eventually goes into Oregon revised statute, right? It becomes a statute that you can find with all the others. But first, it goes through this process of kind of being put in order. It's like putting the chapters and pages of a book in order. I actually did this job years ago as a law clerk working for Legislative Council. So I remember the steps, and I admit even I was saying, can't we go straight to ORS? But we can't. So all of the bills right now no longer in law are referred to as Senate Bill 99. Instead, it's now in Oregon Law 2023, Chapter 567. So I just want to explain what that is. That's simply the current place legally that the bill is listed in its entirety. That's all that is. Okay, thank you. And then keep scrolling a little bit just down to the records. Okay, stop. These are the records that each facility must develop and must maintain. And so we kept develop and implement a written policy that prohibits falsification as the first. And then we inserted everything that was in the statute. Unless required by state or federal law, a care facility shall not disclose any personally identifiable information. And then we listed it. Eugenia, go ahead.
So not that I ever would ask for more rules, Lynn, but I'm wondering if this might be an opportunity for us to do that, because confidentiality of medical and other records for a resident is important for everyone. And I'm wondering if we just broaden that out to say that the facility, unless required or allowed by state law, facility shall not disclose personally identifiable information regarding a resident, including but not limited to, and outline some of those items, including comments around a resident's condition, their mental health. All of those pieces are really important. And I think maybe, like I said, maybe we can actually use this opportunity to emphasize the importance of keeping medical records and care records confidential and private.
I'm glad that came from you, because we love that idea, and we as staff have talked about it, and then we were like, yeah, but we're going beyond the statute, and we might have some of the advocacy groups going, no, we're all for that as a department. We would like to see that, unless that's something that others decide is going beyond what we're allowed to do, but love to have that comment, particularly from you. So thank you.
Well,
Yeah.
the law already requires it, so it
Yes,
just
it
makes
does.
sense to use this as an opportunity to clarify that the law applies to everyone. And here's some additional pieces of information that are critically important to keep confidential.
Thank you. We really appreciate that. And I know there's a comment from Matt, but I can't see it. So
Just about to read it to you.
thank you.
Yeah. Could we also reference HB 3159 from 2021 that establishes confidentiality rules regarding SOGI identity data.
That's a good point. Yes, we can, because we never put that into our individual program regs, but facility, well, let me think. I will want to talk with you about this, and here's why. If those standards apply just to the department, not directly to facilities, if it's just a way that we get information, then we might not want to put it into this rule or into any of our rules. But if it's something that facilities really need to be aware of as well, then it would be appropriate for us to add it. So yeah, Matt, I would love to talk with you later, maybe this week, about that. And maybe you join our group even this afternoon if you have time, because we're going to be doing a debrief and we'll start amending the rule then and looking at all comments. And that's a really interesting one. So thank you. I'll need to know more, and then we can decide as our team edits what we want to do. Yeah, great question. Okay, thank you. Let's scroll down a little bit, David, to show, again, this was the language below.
We have a comment from Liz James before we
Oh,
move forward.
Oh, Liz, hello, thank you, yes.
Yeah, I'll be quick. I
Okay.
just wanted to say, Eugenia, you made me laugh when you said that about adding language, so I appreciate having a good laugh. But I really loved what you said, and I think as long as we incorporate what we have here and add the additional language as Eugenia recommended, I just wanted to weigh in and say I supported that and really appreciate it. So thank you, Eugenia.
Yay. Well, that would be great, because we'd like to add that too. And if we don't have anyone who's opposed for any reason, that's a good legal reason at least, we will definitely do that. So thank you for the support there. Eleni, are there any other comments right now?
No, there are not right now.
Right, thank you. Then let's scroll so we can see paragraph C. And again, this one, yes, sorry.
I'm sorry, this is Deb. I was trying to get there, Lynn, for other
That's
comments.
okay.
I just clicked somewhere else and missed my mute button. So we were looking at the resident records section.
Mhm.
Where is the piece in the rule that directs facilities that they must have, and if I'm going out of order, we'll get there and I'm sorry.
Okay.
But that in the record, they must have the resident's gender identity and chosen pronouns. Are we
Yes.
gonna get there?
We're going to get there.
All right.
But thanks for asking. Yes, because you're right. We put them in the places where we thought would be most appropriate, but it would reference back and would become these records that we're talking about here, right? So that's, but thank you. No, we're going to get to that in just a minute, but that's a
Lynn?
good, yes.
There is a comment in the chat from Patty. I'm wondering if there is a way for the rule to address as a best practice an annual or biannual community facility / resident meeting to highlight and raise awareness of these concepts beyond the poster.
Interesting. We will need to think about that. I need to think, yeah, I don't know right now, but thanks for the comment. And we will consider that and see legally if we could do something like that, because I know that would be helpful and it would get information out. And it's a very interesting thought. Yep, C is where we put the language in the statute. The facility shall take appropriate steps to minimize likelihood of inadvertent or accidental disclosure of information described above of this section to other residents, visitors, or facility staff. So that language is taken from the statute, placed in the rule. We're simply referencing the section above where we've listed the other items that were also in statute, saying unless required by state or federal law, care facility cannot disclose that information. Any other comments on any of this? Okay. Then hearing nothing, let us know, or no additional comments are on page. Okay, can you please go down to page 28? Am I in, actually, I might be. Keep going. Nope, this is right. Okay. This is where we have placed the protections with the poster and the posted information that will need to be handed to residents when they first come in the door and will need to be posted in the department or throughout the facility. So that's the section we're in here, is the one that requires for community-based care, the resident rights, uniform disclosure statement, and the consumer summary statement. It has now added this fourth statement as the other piece of documentation that the department will require facilities to provide residents when they first come into the facility. Deb, go ahead.
Thank you. And I don't want to dominate the conversation here, but just a quick point. That language says the name of care facility does not discriminate and does not permit discrimination. Is this, for those of you who regulate, is this does this language then, do you think, cover potentially those resident to resident incidents, if you will, of harassment, bullying, etc.?
I think what it does is it's more broad than what we saw above, that was just talking about use of a restroom. But it's still doing the same thing where it's saying facility, you as the owners, operators, or your staff may not allow other residents to do these things. So it would still be the facility or the staff that we would be citing, but I definitely agree that's a broader prohibition on what bullying could occur. So that's an interesting thought as well. We're taking notes. Interesting idea. Yes. Go ahead.
Liz noted that yes, she does believe that to be so.
Okay. Yeah, that statement now will be posted in every facility and will be handed out to every resident when they first come in the door. And it will be explained to folks who are already in the facilities once this law goes into effect.
Okay, well, thank you, Lynn. Deb, a good follow-up question. So you interpret this as that the facility, I understand that the facility has the responsibility and would be cited if there was a survey, but do you do believe that this obligates the facility to act in some way as the one who's responsible for enforcing a do not discriminate, even if that discrimination was resident to resident based?
Absolutely, yes.
All right, thank you.
Yeah, we are responsible for that now. So if any resident is, maybe particularly it's sometimes memory care residents, they can wander in other rooms, they can touch people, that's not okay. And it will be our job to then regulate the facility and say, you cannot allow that. And if you did or do, we can cite you for that. So yes, that's exactly what I think that covers. That's a very good point. Any other comments about this section? So this is the posted information that's referenced above. Don't have to go back up, David, that we'd already talked about. It's just that we wanted it in different places. We first had to put it here because this is the section that says when a person first comes in, what information are you going to give them as the facility? Well, this is now the fourth major piece of info that they need to describe and explain to their residents, but they also need to post it. And they need to put a policy and procedure into their records concerning this. So that's why we've had the same language referenced in different parts of the rule, even though we only provide this full chunk of text from the statute in one place, just for clarity and just to keep it a little bit shorter. We're always trying to reference things that are large blocks of text if we can, without making it confusing. And hopefully that wasn't confusing. Okay. Let us go down to one more and then I think we might take a break. So again, this is the resident rights section that we started with a while ago. It just happens to be a little farther down in our language. So we have already seen this, but just as we scroll by again, just to be aware of it, this is where all the rights are placed. And again, those are then referenced in other parts of the language of the rule. All right, then please continue because we've already talked through this and we have comments. And instead, let's see, what page are you? Let's go to page 34, please, David. Realize I've been talking about other things as we go. Okay, there's the move in section. Thank you. Very smart. You're realizing I need to have given you both numbers, where to start. What this section is when a resident first moves into a facility, they are evaluated and screened at move-in. And there are a number of things that we need to ask and the facilities need to ask and to get information about, and then record in that residence permanent record. All right. So what we've done, go ahead and start scrolling, is just to orient you to where we are. That's the section of our rule. There we go. The first place we put this, and the way that we captured it, and I want to make sure I've got this right, but we said you will need to ask the residents gender identity, preferred name, and preferred pronouns. Is this the right way to word it, or should we have said something else? Because it wasn't language specifically in the statute for that. It was more generic, like, have a record or put it into a record. We need to be very specific here. And I want to make sure that we're capturing capturing this terminology in the correct manner. Well, hey, maybe we did all right with it. If no one's yelling, that might be good. Okay. Yes, Liz, go ahead.
Yeah, sorry, I was having trouble getting to my
Apparently, yes.
icon. Well, first of all, you need to remove the word preferred before pronouns.
Okay.
It just is your pronouns.
Okay.
And that's my opinion anyway. And collecting this information, and I'm trying to think about how to say this. So collecting, there's gonna be folks that are not going to want to reveal these things, and that has to
Right.
be okay. So I don't want this to suggest that you absolutely have to collect this data. There's a need to make people feel safe, regardless of whether or not they want to reveal their sexual orientation or gender identity. I like to see the opportunity to collect sexual orientation and gender identity. So those are two very distinctly different things. So I think that we need to collect both. That's what SOGI means: sexual orientation, gender identity.
Yeah.
And preferred name.
And yeah, keep talking. I want to ask you a
So that's
question.
my comment. I wanted to remove, I think just using the term pronouns, I think I've given you my thoughts there.
Okay.
And I think we need to somehow, again, caution folks that these are not, there are going to be folks that won't reveal, and I don't know how you put that into rules language.
Well, there's a way we could okay. I'm thinking right now, before we get to Deb and then Matt, who both will probably have better comments than I'm about to have, but we talked about sexual orientation as adding that in as well, recognizing it as being different, thinking, is that going too far, or should we be doing that? But given what you're saying about preferred, at least in the short term, what I would say we do is we keep the terms there: gender identity, preferred name, and pronouns, comma, if the resident is willing to share that information. We find a different way of saying that, but we don't need to force them to share anything. But I'm going to call on Deb and then Matt, because they may have better ideas. Deb.
Thanks, Lynn. This is Deb. I don't know that my ideas are any better. But I am looking at the statute. Liz, I might disagree with you just a tiny bit. The language in the bill talks about chosen name.
Yeah.
And I don't know if that's a better word or not. I'm going to defer to others on that, but that is the language that's in the bill.
True.
The other piece of this that concerns me a little bit is that this particular section is all about the records that the facility needs to generate in order to serve someone. And in my mind, and I was not involved in the writing of the bill, so those of you who were can tell me if I'm wrong here. In my mind, what this section is doing is really protecting folks who are transgender by specifying in the facility records for the facility staff what their gender identity and preferred, or chosen rather, pronouns are. So in my mind, Liz, this is not a data collection opportunity. The bill was silent on sexual orientation, and I don't know that putting it in rule and saying we will collect that data, I don't know if it's necessary. But that's just my thought.
Well, I'm going to first call on Matt and then ask Eleni to read some comments and then come back to Liz. Okay, so everyone's going to get a chance to keep going. Interesting conversation. So Matt, please go ahead.
Good morning, everyone. So I'm Matt Friesen. I use he, him pronouns. I'm over in the Office of Equity, Multicultural Services. And just two quick thoughts. One is the conversation that we're having here is a conversation that's occurred in lots of different systems throughout the agency. And I would be happy to share what some of the conclusions that they've come to. They've had some really creative ways to think about this and have had some really engaging conversations with groups like the Pride ERG, who have been able to really do a nice job of counseling and providing some guidance on respectfully asking questions that for a lot of us are still sort of new questions, and kind of thinking about how to ask these in ways that help residents feel comfortable and welcome and respected. So that's one thought. The other is, and I just noticed a comment in the chat from Patty, who was making reference to navigating differences between what we often consider legal names and chosen names. And there's also been some really, I think, creative thinking around that as well. So that might be another area that we would explore. Again, I don't know that I want to take up lots of time doing that right now, but happy to help with that later.
Thank you. Wow, thank you. All right, first I want to go to Eleni. Go ahead and please read any of the comments in the chat.
Okay, so Deb mentioned, does the preferred need to be changed to chosen? And then Liz stated that she liked chosen names and chosen pronouns.
Okay.
And then as Matt stated, Patty mentioned, how does a facility navigate the possible difference between a legal name and a chosen name for billing purposes? And Brandy stated that they don't prefer the term chosen identity. And then Liz said, I am updating my comments to eliminate chosen from pronouns. Thank you, Brandy.
Okay, interesting. Thank you. We're going to now go to Eugenia, although she's dropped out. Eugenia, do you have your hand raised? Would you still like to make a comment?
You know, I'm just going to echo Patty and Matt's comments around like a process that allows for billing and other things, because this is going to come up more so even in the SNF world. They have to input data into the MDS, and I don't know that the MDS has been formatted in a way, and this is a federal system. It's nothing that the facility can control. I think the MDS still spits out like gender is male or female, and it doesn't give you a lot of choices on those components of the record. But I think it's important from a service planning perspective. And I think maybe this is the distinction, is that maybe, you know, there may be social security numbers that tie in with billing needs that can't be changed. But in the service plan, the person-centered service plan process, that's really where you can capture an individual's gender identity, chosen or preferred pronouns, preferred and chosen names, because that's how you're going to serve that resident on a day-to-day basis. But there are going to be some barriers with other systems, some of which facilities have no control over.
True. Liz.
Thank you. I just, we are moving to collecting social, sexual orientation, gender identity, and all records. We did add that into our Real D, and the RAC is underway to get that implemented in health records. So it is becoming, and there's, I believe, if we stay on this trajectory, we will have it standardized in everything. So I think that's really important to keep in mind when we stop, and that we collect both sexual orientation, gender identity. And, we've obviously, as Eugenia said, we've got to figure out how to make accommodations for the targeted required records that things go into. In terms of having somebody's preferred name, it is an incredibly powerful way to acknowledge somebody. And if your birth certificate name says Jim and you go by Sally, that solves a lot of issues in terms of making somebody feel comfortable and safe if you refer to them by their chosen name. So I think that particular piece of information is extraordinarily important and powerful, and it's an important tool for staff to use to properly engage and meet people where they are.
I'm going to be very interested in having this conversation before we finish the temp rule. And with as many of you as might want to send in your comments, this has been extremely helpful. And Matt, really look forward to pulling you in to learn what direction you're giving or is happening, or what's happening with the other programs throughout the department, because we would like to be consistent. Yes, we sometimes go rogue on you all, but we'd like to be consistent. Are there any other comments about this? This is a really important one. And I think I'm seeing two key issues. One is, do we ask them the questions at all? So do we collect this data, or do we just let them tell us what their preferences or what their chosen name pronouns are? And then be sure to use those, or do we actively collect the data? And if so, what's the best way to do it? So those are the two. And yeah, I will be interested in hearing from all of you and reading comments, and we'll obviously review the minutes of this meeting very carefully when deciding what we'd like to propose next. Are there any other questions, comments? If not, David, could you scroll to page 37? This is the last thing we're going to do before we take a break. And go up. We just slid by. There we go. So the evaluation, first it says that what needs to be covered basically, but then it has what the evaluation has to include. And so again, this one, just like the one before, we're clearly going to have to look at this because it ties very directly to the one preceding, the question preceding it. And Eleni, could you please read the comment?
Yes, I was just about to do that for you, Lynn. Heather Burks noted that I think it's important to note that there should be they should be required to ask if the resident has the right to decline providing the information. I apologize that was so difficult to get out. And Liz agreed with that, and so did Matt.
Okay. Yeah. So do I, but yeah, it's, well, as we drafted that, it makes, I know we needed, I think that the comments around, but we're starting to collect this data anyway. It is a good comment, and we'll just need to figure out a way to do that as correctly and sensitively as we can. But I want to be consistent with the policies of our department, because people are looking at this issue at this point. And with that, I actually didn't think we'd get this far through this rec. So well done, everyone. But we're going to take a 10-minute break. And when we come back, we will start talking about training and the sections of the statute that apply to our draft rules. Thank you. I'll see you all in 10 minutes. Hello, everyone. We're now back, and we are recording again. And what we are going to do is continue in walking through the bill. First, Section 5 of the bill addresses civil penalties. We have not yet discussed or addressed that issue. Question?
Yes, I apologize for interrupting, Lynn, since we're just getting started again, but there was a comment in the chat upon our return. It was from Heather, and she said, thinking further on this, it should be required that the resident be informed on why this information is being asked, how it will be used, and that it is in no way tied to qualifying for services.
Good points. Thank you.
You're welcome, and I'm sorry for interrupting you.
No, not at all. Please, I should have started with any questions based on what we already did. No, those are really good questions, and those are good comments and additions, and thank you. We'll consider that. With that stated, let's move on to training if we're ready for that. Unless, yeah, so David, if you can scroll on down, and I'll just say for right now, the next section you hit should be, there we go, should be 0070, which is the training section for community-based care. I first want to say something to folks who are familiar with this rule. It's problematic, as probably all of us know who work with it, and it's got a lot in it, and it's detailed, and it's hard to follow where you're going. I did make other edits when we were in this section to attempt to clean at least a little of that up. I didn't change any substance of any kind. I just reorganized things a little differently. So I want folks who know this rule to be aware of that you'll see edits to things more than just the LGBTQIA2S training. All right. Okay. So with that said, we're now in the training section for community-based care, and go ahead and scroll down, please, David. Okay, let's stop right there. And again, all staff must receive a written description of their job responsibilities. That had originally been down in a different section of the bill, and we decided it didn't make sense down there, so we moved it up to just make a statement applicable to all trainings. And then just scroll down, please, David, so the pre-service orientate, there we go. Okay. As I know you all either know because you either wrote it or you were likely involved in one of our first two racks, the training requirements are these. There have to be 2 people. Again, we may argue for just 1 in adult foster homes, but 2, 1 representing management, 1 representing staff in the facility who by July 1st of this coming year need to be designated as the points of contact for this topic. And they need to be the ones designing the training that will be done throughout their facility. All right. And then everyone in the facility needs to be trained by December 31st. So the end of the year, everyone needs to be trained. And then following that, there will need to be pre-service training, which we've put in. It's a standard thing. So that's why what you're going to see here is the following dates apply to the initial trainings. Effective December 31st, all staff must have completed the required online training and the department will begin to regulate for compliance. Then that very next day on January 1st, all new people that are hired January 1 or later, they will also need to complete this training. We know that what we wrote will be a little controversial here for this reason. Because we think it would really be difficult, at least for the department, to review all proposed trainings by the December 31 deadline, we have decided that that very first training, it's going to be an online training that we will develop working with Oregon Care Partners, will be free to facilities, but that everyone should take that as their first training. That is our proposal. And so that's why that's what you're looking at. Scroll down just a little bit, David, just a tiny bit. And okay, thank you, that's good. And that training does need to address all the elements that are in statute. I've put those later into this section of the rule and didn't want to repeat everything and duplicate, but that's what those are referring to. It's referring to all the requirements in section 6.1 and section 6.2 of the statute. All those things have to be addressed. But we at least are proposing that this very first training and the training that's then used thereafter for new staff be an online training that is applicable to everyone. Go ahead and start yelling. No, I'm expecting a little bit of pushback on that, but that's what we're thinking. And that's the reason is we thought if all of you started trying to send us trainings before that December 31 deadline, it's going to be a challenge for us to be able to do a good job of getting through it. Liz, go ahead.
So my question is how, we have become such an online experience world and people don't always pay attention online. I think we always know that. And I think with training online, if we don't have any way to validate that information has been taken in, I think it's problematic. So I know we didn't define this in the bill, but I think there should be some kind of test or validation of the content that was delivered to validate that the people actually paid attention during the training, and so that there's some sense of, even if it's informal credentialing, that they've done it. So that's my thought. I really want us to think about that. And again, I don't know what kind of frame we have in terms of latitude to incorporate that in rules.
And what I just heard from you were 2 things. One, we already do. The other one, I'm not sure about. One of them is, do we require they document this? Yes, the facilities have to document everything. And whenever survey goes in, they look at that. Not all of them. They'll take a sampling to see if they think the facility is correctly tracking all required trainings, but that is a requirement of the law. It's also actually a requirement under our quality metrics program. That has to be recorded and reported every year by every community-based care facilities only. That doesn't apply to nursing facilities or to adult foster homes, but all community-based care facilities need to report every year on all of the trainings that they've done. That piece, I would argue, is covered by the existing law. What is not covered right now, I don't know if there are some trainings that do build in questions and answered in the training. And I'm just showing my ignorance about what a training might be capable of doing technologically. But I know that some of the trainings that we have to take as a department, you have to take tests on every section before it lets you move on. So I'm not sure why we couldn't do that. But anyway, David, or no, yeah, David did raise this.
Yeah, I wanted to affirm for the group that part of the Oregon Care Partners training, there are built-in learning evaluations. So as we create the content, we will collaborate with them to make sure that there are opportunities to practice and demonstrate knowledge built into the online training itself.
Okay, thank
Lynn.
you. Yes, Eleni.
Okay, so there's a few comments. It looks like Patty said, is there a way for Carewell to fold in the training for HCW rather than a separate training? Is this a required training? Will there be a stipend offered? I'm not sure what HCW stands for, Patty, so if you could clarify that, that'd be great. Maybe Lynn knows.
I do not, so thank you. I was going to ask the same question.
Home
then-
care worker.
Thank you. Home care worker.
Thank
Okay.
you. And then another caller who's just identified by a number is maybe require attestation. And then Heather Burks stated agreed all training should require a demonstration of knowledge, learned and testing and a required score to pass. And then Liz noted, David, I intended to communicate, pay attention, not just attend. And then Heather also noted, I do have concerns regarding making sure the person registered for the online training is the one actually taking it and passing a test. We have safeguards in place, and this would also need to be in place for this training. And then Alyssa noted, can you explain the specific rationale for only having one option for this training in 2024? Is it specifically the time it takes to review and improve other training?
Yes, thank you. And thanks for all the comments, and Eleni for reading those. And yes, to address the last question, in the section below where we're talking about the biennial training, that's where we have a process by which folks could say, we'd like to do our own training, and they could submit a proposal to us that would be reviewed, and then we would approve it or not, depending on whether it had all the required criteria in the curricula. So we are doing that, but what we were thinking, the reason we didn't do it up front was two reasons. One, we did want at least one standardized training, and I really appreciate the comments about making sure people actually learn from it and building little test questions into the documentation is a great idea. Not sure how to prove that it was the person who did it, who took it. That's a new one for me, but just thinking out loud. But we can, but we just knew that it wouldn't be enough time. I mean, if we even had a dozen people or our facilities decide to submit proposals, we don't yet have in place a process for reviewing that. And so we need to kind of get our act together. And I really wanted to have at least one training where we knew we could put into it what we think people need to know. And then later in the biennial training, we allow people to do different types of trainings. Maybe you want to do them in person, right? I understand that. Or you want to do a webinar that's at least live. We understand that. So we want to entertain that because it's part of the statute, but I thought we could get flooded up front, and I didn't want us to fail and not be able to respond to you in a timely manner. I'm going to go with Rebecca first and then Naomi, and then we'll go back to comments. Rebecca.
Thank you. Two comments. One is agree if it's online, the most effective online trainings I've done. If I make a mistake, it gives me a teach back. It gives me an opportunity to learn in my mistake. So it's not just a flat, whatever, you miss two questions. It's explaining what the right answer was until I got it right. So that's my first comment. And then my second is thinking about not only language translations for this training, but also transcreation. So like really making sure it makes sense culturally, cross language and other differences for folks. So I don't see that documented here. I know that's often, it feels often like an afterthought to have a training available in a language other than English, but knowing
Yeah.
who our care providers are in the state, I think language access and other access needs to be considered.
Good comments. Naomi.
Hi, everybody. Yeah, so Lynn, I heard you say that, you know, the thought is that there's one kind of training that launches, that everybody gets the same thing up front, but you have in, you know, it looks like in B, you have online trainings for the future as well. And I think we had maybe, you know, we had some thoughts about maybe having some other formats available besides online. I mean, it may be the preference that, you know, it's just easiest and everyone's interested in online, but we'd like to allow for other types of training that would still meet criteria. But if it's so specific in the rule, even for the future ones, then that limits us.
Let me respond to that a little bit. We are following language similar to what we're trying for the HCBS rule, which is a completely different rule that some of you will be very familiar with already. And we're recognizing that with these short timelines, we just can't promise that we can review everything in time. However, we just put in online because that is what we normally do. And I admit, I don't love that either. I'd rather it be in person as well. And maybe we as the department just define one that at least it's a person talking or that it's different. But right now for the initial one, because it was the easiest, but if others can come up with a better way to do an initial training, but that we'd like it to be even across the state, both to ensure that everyone really does get that same information initially, but also because it would be a simpler process, certainly for us, and it's one that we could actually handle. I don't think it has to be online, but I'd love to have other suggestions about how we would do that. And I know, David, go ahead, and then we'll go to Eleni with comments. You're muted, David. Wow, he never does that. That's not a mistake.
Never say never. I wanted to offer some additional information about how Oregon Care Partners online trainings are designed in regards to people being concerned that the person stating they're completing the training is actually the student. When you log into Oregon Care Partners, you need to create a unique user ID. So there's some system built in to verify, unless you have a system where there's actually an exam proctor and people are showing up in a room and presenting ID, you know, that's the fail safe. But I just wanted people to understand you do need to create an account to utilize Oregon Care Partners. It's unique to you, if that's helpful.
Thank you. That's true. And that maybe is the equity. I saw equity issue. Eleni, go ahead and read chats, please.
Okay. So Heather asked, can we make the online training a prerequisite to any future training developed? And then she clarified the first one to be developed and taken to be a prerequisite to attending future training. And then Patty commented, there is a problem requiring in-person training for care providers. It is also is an equity issue also.
Both are very good points. Don't have a perfect answer right now, but yeah.
I
those are both good
apologize.
points.
There was another comment from Heather that just popped up. One of these issues we see is that the owner of the AFH creates accounts for all staff, and the staff then do not get or know their account information. This raises questions of validating who is taking the training. And she said, sorry, but no worries, Heather. That is a very good point, and that absolutely happens. We've seen it.
That's an excellent point. Liz, good point.
This might be a little bit outside the parameters of this discussion, but it's built into it. So with regard to Oregon Care Partners, you know, there are some national training standards. Sage Care has actually been engaged by states to do this kind of training, a couple of the states. And I'm not suggesting we necessarily do this, but Sage is a national organization. They are the most long-term established organization for older LGBTQ adult education and rights and advocacy work. And, you know, I just, you know, want to make sure that however the training gets built, that it's built on top of some good existing standards and that we don't reinvent the wheel and then have something that really doesn't meet the real needs of the folks we're trying to protect.
Yeah, that's a really good point. Petronella.
So I just have a quick comment to make. As far as the training goes, I know that the department goes throughout the state and does these different trainings. Why can't the department do a training that is offered to the providers?
You know, I'll just tell you, I would love to do something like that. I think it'd be really interesting, and I like training, and a lot of us here do. We were not given any extra staff to do this, and believe it or not, we kind of already all have full-time jobs. So that becomes the real question. It's that person power issue of who can do it, who's available to do that, and how long would it take? And I don't know. I mean, I would love to actually have all of our trainings be trainings that we could go out and give, because I think people get a lot more out of that, or at least having that as an option is a good idea. But right now we just don't have the staff for it. But I really appreciate the comment.
And I'm
yeah.
also thinking about maybe the licensors at the local level as well.
Yeah, that's a good point too. Thank you. Thanks, Petronella. Eleni, anything else I should know about?
Yes, there is. Okay, so Alyssa noted there is also project visibility on for aging services, and Heather noted resources and workload. Liz noted Sage Care, and she added the link into the chat. I'm so sorry, I'm stumbling here. And I think that is all for now.
Thank you. Thanks very much for that. Any other comments on the pre-training portion of the rule? Okay, seeing, hearing nothing additional at this point. Again, you can always follow up. In fact, I love it when people actually give me proposed language. It's so lovely, rather than just, yep, there's a problem here. And then I'm like, oh, great. Now I have to think through it. So if you have actual proposed language, that would be delightful, frankly. And anything you want to send in to me will be considered. Eleni, was there another comment?
It was Lynette, and she was, Oh. I'm sorry, Lynette, go ahead.
Oh, sorry. I was just going to say that for Petronella's comment that we are open to the idea. It's one of those things that, you know, if it's available and an option and we're able to do it, we can. We just can't make any guarantees at this moment.
Good points. Anything else? David, could you please scroll down to page 48? And yes, there will be lots of little edits, but again, ignore these. I'm just moving things around and trying to streamline it a bit for the existing rule. And there we go, and stop. Well done. And we have a question. Go ahead, Eleni. What's our next comment? I can just see that it popped up. I don't.
It is from Carrie. Yeah, I believe I'm saying that correctly, and I apologize if I'm not. This is a wonderful group, and I'm so honored to be to have been a part of this. I do have to go to another meeting now. Thank you all for your advocacy and care for this population. And thank you.
Thank you. Okay, David, if you actually want to scroll up a little bit. Sorry for just a minute, and stop. Whoops, go down. We don't have any other biennial trainings in any of our care facilities. At least I don't think NIF does. I know the other two do not. So this is new one for us. And rather than making an annual section and then making a biennial section, at least, and I think that in adult foster home, that Eleni and Kyle did split it out, just to be super clear for your audience. But for this rule and the purpose of the community-based care facilities, I decided to combine it. So it's annual and biennial in service for all staff in one spot. And please scroll on down. And that first, okay, and the infection control section, that exists elsewhere. I just moved it. And the only section of it that we just deleted is the part with the dates, because it was time to clean out a lot of dates that have passed out of the rule anyway. So I'm taking this opportunity to just try to streamline and clean those out. Okay, David, go ahead now, and please go ahead and put just the biennial training. Okay. What we did here, and this took quite a bit of thought, there were a number of us actually working on this just to sort of set a little bit of the stage, is we took all of the rest of the content in section 6 of the bill, and that's the training section, but we reorganized it a little bit. So let's see if this works for all of you. I'm going to be curious. What we said is the biennial training requires administrators and employees shall be required to complete the training. And then the piece that was about the cost, we tacked right into that first paragraph. The facility is responsible for the cost of providing this training to all staff. It's not something that we see in a lot of other parts of the training rule, and rather go into a financial statement of the rule. We decided it would be easier to put it right there up front contained in this rule. If we have a comment, go ahead, Eleni.
Sherry commented, I wonder if we can mandate this training with consideration of the CBA. I'm not sure where
What's the
home
CBA?
care, a collective bargaining agreement, I'm
Oh,
assuming.
of course, your agreement, yeah.
Not sure where home care workers fall.
I'm not sure we are either. At least I know I am not. Lynette and Eleni and Kyle may have a better idea, but Lynette is writing something. Maybe she's responding to that question.
Yeah, Lynette noted
It's
that.
legislative. So at this
Mhm.
point, home care workers or foster home providers can debate bargain the impact of the bill, not the bill itself. So yes, we can mandate the training for both programs just as part of that legislative directive.
Thank you. Any other questions or comments on that first paragraph as we start? Because then what we decided to do was to try to put those two employees directly under that first section. They are separated in the statute, and it wasn't making sense to us in terms of the rule construction. So we did state the facility shall designate two employees, one who represents management and one who represents direct care staff by July 1st of next year. Eugenia.
Oh, you can continue. It's about the section in general, so I want to go ahead and finish.
Okay, got it. And then paragraph 2, we said those designated employees shall serve as the points of contact, again, pulling language from the statute regarding compliance with the pre-service and biennial training requirements. These individuals shall develop a general training plan for the facility. Scroll up, please, a little bit, David.
Lynn.
Yes, no, the other way, I meant down. I apologize. Go, yeah. Thank you, stop. That's far enough. And Eleni.
We have some comments. We have a comment from Anna Petrus saying that she has a comment. So when we're done reading all these other comments, then maybe she can unmute. Heather said, could the 1 or 2 persons need to be tied to the number of employees? For example, if under 15 employees, 1 person required. If 16 or more employees, 1 management and 1 staff required. And then Patty commented, having just bargained the CBA, which is also known as the collective bargaining agreement, there is no language around this type of training, but the state can request to bargain over it.
Okay. Before we go to, who is again the person who said that she would like to make a comment?
Anna.
Anna, can you please go ahead, Anna, and make and take yourself off mute if possible and give us your comment. It's Anna Petrus, yes? Okay, I'll give you a minute. You are unmuted.
Okay.
It doesn't work.
It doesn't work. Lynette, maybe you can try to unmute Anna.
We're going to try.
Okay. I'll give them a minute to work
No,
on it.
It shows her as unmuted, so there's not. If I touch, I will mute her again.
Okay, mute and unmute. See what happens. While they're working on that, Eugenia, please go ahead and share your comment.
Yeah, I am wondering if we can add language in here around either like the designated employees or their designees to develop that training plan, because understanding how facilities work, it may be a regional support person that develops a training plan for a couple of buildings if they're related to the same ownership group, or maybe a larger chain. It may not be facility specific and want to give facilities that flexibility that it may. Understanding it's important to have someone at the building kind of monitor compliance, get questions, respond to them. But sometimes these training plans are developed at a different level and by other folks. So want to make sure that there's that flexibility. So if we could add in, these designated employees or their designees.
I believe that's what we did in the infectious disease control section. So maybe we can try to use the same language. And yes, that does make sense, at least to me, as I remember drafting that into the other piece. So we should probably just duplicate that here. And let's see. Any other comments, Eleni?
Liz is stating that she supports Eugenia's comments.
Okay, good, thank you. Appreciate that. Any other comments about just big A here? Which is, just stating they've got to all complete it and then designating the 2 staff who will design the training program. If not, then let's scroll down, please, David, to big A, which is right at the bottom of the screen. We still, as the, okay, let's go, right? Yeah. Go down a little bit, please, just so we can see the big B if possible. At least it's not, okay, and stop. Perfect, that'll work. Thank you. Big B, facilities may choose to use the department-approved online biennial training. We intend to have a second training. And I don't know if that's enough to be the follow-up that was suggested earlier, but we do want to have available at least an online free to residents, free to facilities training, probably again through Oregon Care Partners that could be used. And again, though, because the statute says we need to provide an option for facilities to develop their own trainings, this is where we're now going to get into that option. So we did say see facility. So basically we're trying to give both options back to back. First, you might choose to use the one the department's approved. If you want to do your own, you can also apply to do that. Before we scroll down, Deb, go ahead.
Yeah, I'm gonna go back, sorry, to the online discussion again. Just wondering if we can just take that online word out there. Facilities may choose to use the department-approved biennial training so that we're not stuck with only having an online option.
Good idea. Yes. That makes sense. And probably even putting that up above if we come up with a different training or we come up with a couple of trainings and options, we may take that out even out of pre-service is what I was thinking.
Right, and we might want to put after the word training at the end of that sentence, a little S in parentheses, so it
Good
might
point.
be more than one.
Yep, that's a good suggestion. All right. David, as soon as, I'll let you finish that. Oh, and then Anna, go ahead. I can see the top of it. Eleni.
Yes. Okay, so Anna said, 1, I'm concerned about the facilities having to pay for the training. 2, I'm also concerned the availability of the training. Local counties have been known not to have trainings available in a timely manner so that we can hire employees in a timely manner. And 3, have multiple and flexible available training options.
Okay. Deb and then Eugenia as additional comments.
Oh, my apologies, I forgot to lower my hand. This is Deb. Ignore me.
Eugenia, go ahead.
So I think around the employer being related for training, and maybe I can provide some clarification around why that was in the bill. We'll get to it later. It's related to the contractors. I think the reason we put that language in there is that facilities should only be responsible for providing training to their staff. We can ask contractors to comply and meet certain training requirements, but we didn't want facilities to be responsible for paying those contractors to complete the training. So I think I think when we say the cost of it, it's not that they have to be out of pocket. Certainly there may be some free trainings that will be available. It's just making sure the staff that are employed at the facility have received the required training. Not that they have to pay for it necessarily. I mean, if it's a free training through OCP or other resources, it's just making sure their staff members are going to those resources and getting the required training.
Yeah, I will say that I think we should have at least an online training that would be an option for the both pre-service and the biennial, simply because I know that can be difficult for people to get themselves to a live training potentially, etc. And that's free. The Oregon Care Partners training is free to facilities and to residents. What I remember seeing in the bill was that it stated pretty clearly that first the facility would be responsible for the cost of trainings to the facility staff. And then the contracted staff would be responsible for paying for their trainings for just there. So it's not, there's no cross costs associated. The problem, as already been stated, is how in the world are we as the department going to regulate contractors? So that's what we haven't drafted yet, because frankly, we kind of got stuck. And so we decided to realize that what we'd done, which took us several days, literally working full time, was about as much as we could do for this meeting, but we're going to start working on how we can possibly try to implement that, what the best way is to implement that part of the statute. Eleni, any comments?
There are no more comments, but I just wanted to note in relation to Anna's comment that, you know, utilizing the free training that Oregon Care Partners is going to be putting on for us would be a really great way for adult foster home providers to have a free option that's online and available to them. And then they wouldn't have to come up with their own. It'd just be something they could send their staff to. So I think that that's a great option.
Yeah.
And then now there is a comment actually. Rachel Hansen said, what's the timeline on availability for OCP's training that qualifies for this?
Okay, I don't know exactly when it'd be available. Generally, what I know is that what we would do is develop the curriculum, probably working with a lot of you to make sure we're getting it right. And once we have the curriculum that you all want, then we send that to Oregon Care Partners. My understanding, it takes them at least a month to then turn that into a training. So as soon as that work could be done, we could make that first online training available.
Lynn?
Yes.
There's a few other comments from Anna. She said, what's the difference between this training and other required trainings? And then her next comment was, aren't all trainings just as important?
Do you mean training specifically, Anna, dealing with the LGBT issue? Are you talking about trainings like for infectious disease or dementia training? Want to make sure I'm understanding exactly what you mean. Well, why she writes about that. Do we have other comments? Okay, Liz, go ahead.
And this might answer that question about, I'm assuming that question about what's the difference between these two trainings.
Yeah.
The intent in this bill is this is new information for a lot of folks to begin with in terms of training. And it's really more of a refresher course. It is to help ensure that there is uptake on this training. And that's why there is this second training. And it is a best practice in other parts of the country that have implemented this type of statute.
Thank you. And I think I saw something, at least the beginning of it, saying she's comparing it to our other trainings.
Yes.
This would be it would be identical in how we would regulate it. And frankly, a lot of our trainings are online, probably most that are required. And a few of them are also biennial, some are just a one-time. Like it's interesting, but dementia care is biennial if you're a direct caregiver, but not for other staff. But the infectious disease control training is an annual training for everybody. And I think I said biennial for dementia. All the others are annual. They're just different audiences. We're actually trying to put this program together in a way that would be very similar to our other trainings to the degree that we can, just for consistency across the board. I don't know if I've addressed your question.
And then Lynn, she also added, I own a memory care and our employees have current required trainings.
Yes, they do. And yes, it would add another one to that list. Yes, that's true. Any other questions at this point? Okay. Scrolling down. So now we know that every facility for the biennial and can either use whatever the department has out there that's an approved training from the department, or might choose to use their own. If they want to give us a proposal for their own training, I have included here all of the elements that are in section 6 as the required language. The first two elements, the little I and I never know if it's an I or 2I, whatever, the little one and little double one, those are straight out of the statute. They're they're section 6, paragraph 1. And then the next, thank you for circling, well done. It's like Vanna White here. The next one, the little 3, trainings must also include requirements. Again, this is a reference to the current Oregon law section that will ultimately be an ORS site, an Oregon Revised Statute site for section 2, paragraph, or section 6, paragraph 2 of the bill. And that's a section that has a list of the required elements of the training. And both to keep this shorter, but also to help people understand the importance of it, I thought, again, using the statutory site, which we do occasionally for reasons such as this, makes sense because it does make people go back to the statute. I think that's important. But also it keeps this section of the rule a little bit shorter, but we've included all those requirements. And finally, the little 4, individual or entity providing the training must demonstrate a commitment to advancing quality care for LGBTQIA2S+ and residents living with HIV in the state. That was elsewhere in that section, but in looking at it, I thought, it's actually really a requirement. So that's why it's now been added as one of those straight requirements when a facility proposes the training that they would like. Then please go down to section E, David. Thank you. And to submit a proposal that a facility shall submit it to the department. We don't yet know who. I'll be honest, we're worried about the workload on this because we don't really have staff to do this specifically, but it's in the statute. So somehow we're going to figure that out. And then once we have gotten what I was thinking initially was once we've looked through it and made sure that at least those elements listed above are all included in the proposal, we will then submit it to a training review committee. And I'll be honest, we don't know if we need to create a group, maybe ask some of you to serve on it. We just don't know how to set that up, but I think we really do want a training group with background with this topic, commitment to these issues to review the criteria and really help advise the department on whether or not it's a good program, because I think we just need help with that. And then what they would be looking at as specified in the statute are those 4 little items below. Qualifications, the proposed methodology, the outline of the training, and copies of the materials to be used. Again, that language is straight out of statute. We just decided to try to give that responsibility to this committee that's not yet in existence, of course. We'll have to figure that out. I'd actually really welcome suggestions on how best to do that. And then please do scroll down a little, David, to the little 3. Then once that committee has reviewed it, you will make a recommendation back to the department, because ultimately the responsibility is ours under the statute to approve the training. And so go down a little bit more. And thank you. And then the department will inform the facility of the department's decision to approve the training no later than 90 days after the request is submitted. And again, that 90 days is going to be a little tricky, at least at first, until we have a really functional process that we use to review everything. But that's also straight out of the statute, which is why the 90 days requirement is there. Questions about any of that? Anybody want to serve on a committee? Just scroll back up a little bit, David, just so they can sort of see what we laid out. Again, this is us, because the statute did say the department needs to design the process, so we did. And I'm hoping it's a process that you can all live with and seems reasonable, but I will just let you think for a minute and wait for just a minute. Liz, Lainey, can you read that?
Yes, Liz said, put my name in that committee hat, please, Lynn.
Thank you.
Yes, we really appreciate that, Liz. We need all the help that we can get.
I'll tell you, initially, I was hoping to use or to assign this and hope that the coalition that actually drafted the bill could do it. But Deb was setting me straight yesterday saying, Lynn, it's not like an ongoing standing committee, so we can't really give them that workload. And also it would need to be volunteer, and you folks would need to sign up for it. We also thought about asking the soon to be formed subcommittee dealing with LGBTQ issues that the governor has to propose the members or approve the members for that subcommittee by September 1st. And we were wondering if we might be able to talk to them about potentially taking this on, but the subcommittee will need to decide what their role is. Don't know if they'll have time or be willing to do that either. So ideas that are creative that help us do this would be definitely appreciated. Other than that, that is as far as we've gotten so far. Again, we were struggling a little bit with the contractors and just what we can do and how far we can do it. So that language isn't here yet, and neither is language dealing with the civil penalties specifically. So we have sort of ended, and I did not think, honestly, we would get through the whole rule, and I'm very impressed by all of you. Great questions and comments throughout. It's exactly what we were hoping that you could give us. Yeah, but people are being, very positive, and this is great. Any other part of the rules, such as what would you like? I can now see your comment. Anna, I see you say, are you guys going to talk about any other parts of the OARs? Not today, unless you have a question. Otherwise, but I'll give people just a minute to think. If you have the next meetings, as well, we talked right at the beginning, you might not have been here yet. But our next meeting, let me see, I need to go back to the document again to remember exact dates. I'm never good at remember those. Hang on. Come on, agenda, come up for me. It's not going to do it right now. Eleni, if you remember, or David, the next deadline for all of you and all of this information, it's in the agenda for today's meeting, which for some reason I'm not able to open at the moment. A little frustrating. Thank you. But we've actually got two things that we're asking now from you. First really was to help us with all these comments today. Very grateful for everything we got. I really do think this will help us refine and improve the rule that we've been working on. So I thank you for that. We also would like any written comments, and you can write the same things you said, or if you have other ideas, but we need them by close of business 1 week from today. And there we go. Thank you, David. So you'll see there that the deadline for you all to comment is Tuesday, November 14th. In writing to us, if you have other thoughts about what we've talked about today, or maybe you have, proposed language for how we handle the contractor section of the rule, or any other kinds of edits addressing the statute. But the next time we will meet will be on Wednesday, December 6th. And again, each of those meetings, those racks that you can see, the December, January, and February, and we might not need them all. Frankly, this group this has been great. It's going more smoothly than some racks go, to be perfectly candid. I've been really quite impressed by comments and questions. And we might not need, say, the February rack at all. We might be done in January. We do need to hold one rack in January because that's when a permanent rule will then be in process, and we have to hold one during that time period. But I suspect we'll still have things to talk about in January. So, but the next time you would hear from us will not be until December 1st, because that's our deadline to submit the temporary rule language so that it can be filed by January 1st. And we won't be coming back to you before that with other comments and questions, unless I get something from one of you in an email that I'm like, I don't know what they're saying. Then I might call you up or might ask you to explain it further. But other than that, the next time you would hear from us is we will send the rule that we are going to file as a temporary rule. We will be sending that out to all of you on December 1st, the same day that we file it downtown to become temporary. Once you get it on that date, again, if there's something in there you really hate, don't panic. Again, the rule is temporary. And then as we continue our last two meetings, we will then, our three meetings potentially, if we need all three, we will refine the rule during those rule advisory committees before we finally post for a permanent rule. Does any of that, is that clear? Any questions? I know it's a lot of our rule lingo and process that a lot of people are going to say what? Or not. Well, I want to thank you. We got through everything that we have for today. And again, our coordinating committee will be meeting later today to discuss what you've been providing and to start those edits. And I look forward to hearing or seeing any written comments from any of you by next Tuesday, November 14th, close of business. And other than that, the next time we would see all of you will be on December 6th. Again, you will have then had the language for 1 week. You'll have what we filed as temporary for 1 week. So we're going to pick up just like we did today and continue to edit the language before we can refine it enough to become a permanent rule. Any final questions on any of that? Liz? Oh, thank you. Thank you, team. And I can see that one. So actually, Eleni, I can only see part of that one, but it's all right. I think that's kind. Well, then thank all of you for your very thoughtful and considered and considerate comments. I appreciate all the respect today with everyone. I didn't know what we would get, and I was very pleased and proud of the way this group worked, and I want to thank you. It was a joy to facilitate for today. All right, with that, we're going to sign off, and we'll see you all December 6th. Bye, folks. Thank you.